USCIS Reform, or Reform of Processing of Immigration Cases in the United States. Surely that's what it looks like. The recent news from DHS stating that they will be changing the processing times and allowing certain applications to be considered using expedited or premium processing. We're going to discuss this news today. We're also going to talk about some other interesting immigration topics. Thank you very much for joining me. My name is Alena Shautsova, immigration lawyer from New York, and we are going to start. Just recently, Department of Homeland Security issued a statement saying that in response to the growing backlog of 9.5 million cases, they are going to take some drastic measures and are going to review the way the cases are being processed. Government is going to focus on processing the cases, at least some cases, faster and allowing for premium processing for larger amount or different types of applications and petitions. Considering that an average case for adjustment of status based on marriage currently is taking a little bit longer than a year, or that a person has to wait for their work permit for about 7 to 9 months, and of course don't forget crazy backlog of asylum cases of several years if you filed your case prior to 2018, this is great news. Now, what we do not know is when exactly this process is going to be implemented. We do not know that. However, of course, we have great hopes that it will start pretty soon. According to DHS, the process for certain new applications that will be allowed to be expedited for a fee, of course, is going to be starting whenever it's feasible. And interestingly enough, the government mentions that it's probably going to be tied up to the DHS opportunity to accept applications electronically. Very, very interesting. So there is a lot of going on. Basically, the government also has to reform the way they accept applications. You may know that currently majority of the applications and petitions must be filed by paper, by mail. And personally, I do not really trust the electronic system, but I know that many lawyers are using it and some people are using it as well. You may enjoy USCIS account with the quick updates, but you also may find yourself at times in a difficult situation when you file your application online and you are not receiving paper notices. However, you were expecting paper notices but did not receive them, and you missed an important appointment for fingerprints or an interview or request for more evidence. And of course, for that reason, because the system sometimes doesn't work the way you would expect it to work. Because if you lived in the United States for some time previously, you expect the notices to be sent to you by mail. And I received many phone calls from people who found themselves in a situation where they just didn't understand that everything will be processed by email notifications rather when they sign up for that USCIS account. It tells me, of course, that it may take some time for the system to start working without issues. Now we're going to discuss for which forms these new rules are going to apply and how long, according to the new processing goals, it will take to process certain applications like naturalization or I-45 adjustment of status form, or let's say work permits and so. The new rule is going to go into effect on May 31st, 2022. This is very important. It means that right now you cannot pay that premium processing fee yet to expedite your case. You also need to know that currently premium processing is already available, but for a very limited amount of employment-based cases. So this new rule is going to allow certain employment-based cases, specifically EB1 cases for multinational executive or manager, and EB2 national interest waiver cases to be considered very fast within 45 days if a person would pay $2,500 or $2,500. However, what personally I find very interesting and good is that the new rule is going to also allow applications to change or extend status to be also filed using premium processing. Specifically, persons who would like to change their status to F1, J1, M Mother 1 will be able to do so if they pay $1,750, and for that money USCIS guarantees they're going to process your application within 30 days. It's very good news, as you may know, sometimes people who are trying to change the status find themselves waiting for that change for months, and sometimes even longer. During the pandemic, it was even longer. So this is very good news. But the best news is that premium processing is meant also to be available for those who are filing for work permits. For a fee of $1,500, $1,500, USCIS promises to adjudicate Form I-765 within 30 days. This is a great, huge change. Of course, you also will have to pay half the amount of money. $1,500 for most people is going to be a lot of money to pay. But if we take into consideration that some people are losing their jobs because of the lapse in the employment authorization, I believe they will have customers who are going to opt for this option. What we do not know yet is for which categories this particular process of using premium processing will be available, which categories of employment related forms I-765. Hopefully, we're going to find out shortly. Finally, the most interesting part, processing times. If you are someone who is waiting for their petition or application to be considered, you know that the process can be very frustrating because you may be waiting for months, sometimes years, for your application to be considered. And these slow times of processing, that's why we have this 9.5 million cases waiting to be adjudicated, right? Of course, there were different proposals as to how to address this. And whenever somebody is waiting for their case to be decided, as you may know, you may use such tools as Congressman assistance or Ombudsman USCIS assistance if your case is pending beyond the processing times to try to expedite the case. But when the Congressman or Ombudsman looks at the published processing times and finds out that application for adjustment of status processing times can be 36 months, they're telling you, well, right now we cannot help you because your case is within processing times, even though it's been pending for 2 years. So guess what? USCIS publishes new goals, new processing times, which are, of course, very, very optimistic. For example, they promise that, or as a hope for, or maybe they just tease us, that certain applications that currently are taking years to be processed will be processed within 6 months. Among those applications are application for VAWA petition, Form I-360, application for an appeal or motion to reopen or reconsider, Form I-290B, application or renewal for DACA status, I-130, I-29F, I-140, employment and family-based petitions, and N-400 naturalization petition application. You know what's also interesting is that certain applications USCIS says will be adjudicated within 3 months. For example, I-765 work permits, I-131, application for advanced parole. Change of status form, I-539. Also, the goal will be to adjudicate it or make a decision within 3 months. But remember, if you pay premium processing, it will be 30 days. So if you're in a hurry, it will be 30 days. Of course, these goals usually are just goals. It doesn't mean that USCIS guarantees that your application will be considered that fast. But surely it's a great beginning. And if it will in fact work, it will be just amazing. Finally, I wanted to mention certain also good news about USCIS. They again extended the window of if you are receiving certain requests for information or decision within a special time, you will be able to get more time to respond or to file an appeal or motion in response to those documents. Specifically, if you are receiving correspondence from USCIS dated March 1st, 2020 through July 25, 2022, you're going to have 60 more days to respond to requests for more evidence, for example, or notice of intent to deny. And you're going to have also 60 more days if you would like to file I-290B or N-336 or an appeal with regard to denied naturalization. But if those documents need to be filed in response to the decisions you received from November 1st, 2021 through July 25, 2022. So at some point, USCIS was giving more time to respond to requests for more evidence, but 60 days more, but would give you only 30 days more if you had to file an appeal. And starting November 1st, 2021, they started giving you equal amount of more days to respond and file an appeal if you have to. So the rule changed a little bit. My advice would be is this: if you are planning on responding to requests for more evidence, filing an appeal or motion, simply consult with an attorney. And lawyer is going to help you to determine how much time you actually have to file a response to a decision or a notice from USCIS. A lawyer will be able to verify for you the correct amount of time you have. And remember, you're going to receive a standard decision text saying that you have to react usually within 30 days if we're talking about an appeal or motion. But in reality, right now, by default, you're going to have more days, 30 or 60 days more, depending on when your decision was made. At this point, it's 60 more days, starting with November 1st, 2021. So thank you very much for watching. I hope this USCIS update was helpful and hopeful. I hope that everything USCIS is promising will be in fact implemented and will work. And of course, this will change significantly the landscape of USCIS immigration, how forms are processing, and it will affect your cases directly because lawyers usually help clients to plan for their future in the United States, what they can and cannot do. For example, if they can or cannot travel during the pendency of the applications based on the processing times. And now if processing times will in fact change, it will have to be taken into consideration if you're planning your life in the United States. Thank you very much for watching. Don't forget to subscribe to my channel, like and share this video, and I hope to see you soon.